But, my lord, it is made or tailored in peculiar Indian situations. It's not word by word thing. That's what, my lord, Dr. Ambedkar also says, that it is uh, derived from in Constitution of Ayr, which is Ireland. But Ireland was a theology.
That history of being uniquely Catholic in a Protestant monarchy
Yes.
or an Anglican monarchy.
An Anglican, which, my lord, they used to oppose, and there was rebellions and revolts and etc. etc. So, my lord, and similar, my lord, Christianity, I'm not, my lord, going into it because this is not what your lordships would be essentially. My lord, Buddhism also, my lord, please come to page 115, 160, which is, my lord, the PDF page 160, my lord, 3. I just want your lordships to see the chart that Buddhism is not, my lord, one denomination. That's the, my lord, possibly our lack of assistance, that in all earlier judgments, we never, my lord, pointed out that this is the internal plurality within one religion. So your lordship's view also will have to be, my lord, suitably examined. My lord, Buddha's teachings, that starts, my lord. Then oral traditions, 18 schools were developed. First notion of Mahayana Buddhism, my lord, etc. etc. Chinese Buddhism is different. Then Vajrayana Buddhism, my lord, which traveled from India, my lord, which is now being practiced, essentially Mahayana and Vajrayana in Bhutan, Ladakh, Sikkim, etc. My lord, that's not the purest form of Buddhism as Lord Buddha preached. It has, my lord, some element of Shakti. Tara.
Tantricism.
Yes.
It's a hybrid between Tantricism
Tantrism.
and Buddhism.
It is, my lord, Shaiva Tantrism. The Muni Padma Sambhava in 8th century made a fusion of Buddhism and Shaiva Tantrism, and that is the form of Buddhism which is, my lord, in vogue in Tibet, Bhutan, Sikkim, and other, my lord, areas. So there is an internal plurality, my lord. That's all I'm trying to, my lord. Then Vajrayana also, my lord, which has, my lord, next page, my lord, I have given several branches. And, my lord, Christianity, with whatever limited, my lord, understanding I could gather, my lord, because these are general things, my lord, and I have done my own research only to show it is not one thing to say I am dealing with Christianity as a religion. Your lordships will have to decide several things, and the question would be, would the court have the necessary expertise to go into those questions? Your lordships may bear in mind, in most of the cases which we cite for the findings recorded or the ratio, but all those cases came from civil suits. Whether, most of them, whether religious practices, it is a long religion practice, etc., etc. So, my lord, this is early Christian church, Eastern Orthodoxy, Roman Catholicism, Protestantism, and, my lord, there are some, my lord, sub denominations within one larger denomination. So, my lord, kindly bear this in mind. My lord, in India also, my lord, at page 170, which is, my lord, at 173, I have given, my lord, Indian Christianity also, my lord, year-wise, how, my lord, they have separate denomination. The doctrinal beliefs are same. And one holy book, my lord, that is Bible, that is common. The founder is common. But doctrinal differences, principled differences, etc., interpretative differences also maybe, my lord, a worldly word, my lord. It's not difference, but another way of looking at the same thing. And that is how, my lord, this plural, internally plural religious practices, my lord, develop. Now, my lord, coming back to the main matter now, please have a look at, my lord, something which, my lord, in my respectful submission, subject to being corrected, is missed. Lord, when we interpret Article 25 and 26, which can never interpreted without looking at the preamble. Your lordships have always interpreted fundamental rights in light of the preamble. Lord, at least the judgments which I could see, and I would place some paragraphs, Lord, this part is not specifically noted. Please have a look at page 5, which would be, my lord, 8, my lord, PDF 8. I'm just, my lord, your lordships have read and reread preamble several times, but in this context, only one right, my lord, what we have given to ourselves. My lord, I have highlighted in red color. Your lordships have in red color, my lord. Liberty of thought, we are not concerned possibly. Expression, it can be 19(1)(a) expression or expressing religious belief also, because if we go by egestem generis, expression, belief, faith, and worship. This is what is ensured in the preamble. My lord, your lordships may consider, my lord, requiring Article 25 and 26 be interpreted, keeping in mind the faith and belief also. Because there can be several things which are capable of belief system. It may not be emanating, my lord, as a, this is necessary because of the unnecessary doctrine of essential religious practice being introduced. How do you decide? It's a matter of faith. It's a matter of belief. Whether this is essential or this is not essential, you will have to first examine and make a judicial review of religious scriptures. You will have to understand the religious scripture the way it is meant to be understood, which is impossible, my lord, unless we achieve that level of spiritual supremacy. We will also not be in a position to assist what exactly Prophet Muhammad said, or for that matter, my lord, Lord Jesus said, or my lord, the Veda says, or Upanishad says, other things they will say. And based on that, my lord, there can be a faith and belief system which is developed, which is not otherwise contrary to public order, morality, health. And part 3. Then how would your lordships examine the essentiality of that? So that's the purpose, my lord. Now, my lord, coming to how, my lord, the 25 and 26 was framed. And I'll be citing this, my lord, so that it's, I'll have to show the route, my lord, because this was not shown, my lord, earlier to earlier benches, or maybe it has missed or whatever, my lord, I'll not. My lord, the first part is what happened prior to the Constituent Assembly set to debate the draft constitution placed before it. Well, before that also there were proceedings, there were committees, committees on minorities, committees on religious freedoms, etc., my lord. These are, my lord, also this is, my lord, pre-Constituent Assembly debates, deliberations on 25 and 26. I have confined it to 25 and 26. For completeness, I have placed everything, but I have marked, my lord, what is not to be read, because it is irrelevant for the questions to be answered. Now, kindly see at page 10, my lord, PDF 13. This is how, my lord, the first draft was placed by Kanayalal Munshi. No, the 3 comes there, the subsequent.
It was taken up earlier.
Please, religious and cultural freedom. They are discussing 25 to 30. We are not concerned with anything other than 25 and 26. All citizens are equally entitled to freedom of conscience and to the right freely to profess and practice religion in a manner compatible with public order. I'm sorry, page 10 and page 13, my lord, if it is PDF. Printed page 10.
That's it.
Yes. All citizens are equally entitled to freedom of conscience and the right freely to profess and practice religion in a manner compatible with public order, morality, or health, provided that economic, financial, or political activities associated with religious worship, please underline this, religious worship was the word initially, shall not be deemed to be included in the right to profess or practice religion. your lordships would might, the word propagate is not there. Something turns on that. Therefore, my lord, I am pointing out at this stage. Then, my lord, 2, your lordships can skip. Citizens belonging to national minorities in a state, whether based on religion or language, have equal rights with other citizens in forming, controlling, administering at their own expense, charitable, religious, please mark, this goes ultimately, my lord, in 29 and 30. There cannot be any educational institution of either a linguistic minority or a religious minority, which is educational religious institution. Nothing turns on that for these questions, but I'm just, my lord, pointing out because one of us, my lord, is going to raise possibly the question that 25, 26 applies to educational institutions also. And social institutions, schools and other educational institutions with the free use of their language and practice of their religion. Then no person may be compelled to pay taxes. Well, this becomes Article 27, we are not concerned. Religious instruction shall not be compulsory. This becomes Article 28 in a different format, but we are not concerned. Then no person under the age of 18 shall be free to change his religious persuasion without the permission of his parent or guardian. Conversion from one religion to another brought about by coercion, undue influence, or offering of material inducement is prohibited and is punishable by the law of the union. Please turn the page over, my lord. Then, my lord, Article 2, my lord, there is some. Dr. B.R. Ambedkar independently circulated a memorandum. I have said that. There were 3 drafts, but period, I have said. I'm not as conversant as you, but I have said it subsequently. Yes. Yeah, continuously I am overhearing you. Dr. B.R. Ambedkar independently circulated a memorandum and draft article. My lord, his draft article was like this. The state shall guarantee to every Indian citizen liberty of conscience and the free exercise of his religion, including the right to profess, to preach, and to convert within the limits compatible with public order and morality. My lord, this was the draft suggested by Dr. Ambedkar. My lord, now please see, my lord, Rajkumari Amrit Kaur and Dr. Hansa Mehta, my lord, 2 eminent lady members. My lord. India, my lord, has always not only, my lord, treated ladies equally, they have always been treated at a higher pedestal. My lord, there are several judgments of the recent past where, my lord, there is a concept of patriarchal society or, my lord, there is some gender stereotypes, etc. They were never there. We are the only generation, arguably, we are the only, my lord, Indian society, we worship ladies. The President of India to the Prime Minister of India to the judges of the Supreme Court, we bow down before our lady deities, my lord. So let us not introduce those concepts of patriarchy and, my lord, gender stereotypes, etc. There has never been. So, my lord, these 2 eminent ladies, Rajkumari Amrit Kaur, my lord, who became the first health minister in Pandit Nehru's cabinet, my lord, they raised.
Call them the founding mothers.
Founding mothers.
We always say founding fathers.
Yes.
Of the constitution. So let us call these 15 women.
Yes, founding mothers of the constitution.
Yes.
Correct. Now, my lord, they had pointed out a correct problem.
Oh, yes. These 15 women.
Yes. It's biographical narration.
Participation in the committees.
Committee also.
In the assemblies, their contribution and how some of the articles, especially Article 15(3).
And, my lord, even 25, 23. My lord, their objection was, apropos your ladyship's, my lord, very right and pertinent observation. Their objection was that if you say right of religion, some religion forbids what otherwise our social reformers have prohibited. For example, somebody may say sati pratha is a part of the religion. Somebody may say child marriage is a part of religion. So he said that you will be nullifying all reformist actions which have been successful by way of laws preventing all this. That was, my lord, a very pertinent objection raised by Rajkumari Amrit Kaur. And, my lord, she says, article so-and-so of Mr. Munshi's draft was Lord, kindly now turn to page 13. Your PDF page would be 16. My lord, I'm just making a reference. Nothing turns on that for the questions. But Sardar Harnam Singh said that you specifically clarify that right to carry a kirpan is a part of our religion, which was accepted. No, that's what, my lord, I have said. Then 27th of March 47, the subcommittee accepted Munshi's formulation of anti-conversion clause, which was clause 7. My lord, same thing which I read, my lord, was accepted. Then, my lord, 31st of March 47, as I pointed out, Rajkumari Amrit Kaur, on behalf of herself and Mrs. Hansa Mehta, wrote to B.N. Rao, my lord, who prepared the first draft. It was Sir B.N. Rao, my lord, dear lordships are aware. Emphasizing that many oppressive practices, that is child marriage, polygamy, untouchability, are justified in the name of religion. They proposed narrowing the right of freedom of religious worship rather than broader practice of religion. My lord, therefore, my lord, she suggested that we should have not have religion, but some other word may be used so that earlier wrong practices may not come back. Your lordships can skip that. My lord, please come to page, my lord, 14, next page, my lord. First conjoined draft report of the Subcommittee on Fundamental Rights was published. It contained clause 16 and 23 on religious freedoms, including right to profess and practice religion, subject to order, morality, and health. Kindly mark propagate was not there. It was only practice and profess. Rights of religious denomination to manage affairs and own property, prohibition on compulsory religious taxes, anti-conversion clauses, that is 22 and so and so. My lord, then see, my lord, 16 is what is 25 today. That's the only thing which needs to be seen, my lord, on this page. All persons are equally entitled. Please see, my lord. These words are introduced for the first time. Now, kindly pause here for a moment. Why am I insisting or emphasizing on this? Lord, Sabarimala judgment reads that equally entitled includes gender equality. My submission is going to be on interpretation. Gender equality is already taken care of in Article 14 and 15. They are equally entitled. For them, it need not be repeated. Why they are saying equally entitled? The framers were aware that we are dealing with a pluralistic society. And my lord, there is a discussion that one religion may not claim better rights than the other merely based upon the numerical strength. And your lordships would also bear in mind, my lord, the date is 3rd of April 1947, where, my lord, the partition process had started, communal riots were taking place, and the framers of the constitution were aware about the concern that one religion may, based upon the their numerical strength, might try to get something more than the other religions. And therefore, they added the word equally entitled. It has nothing to do with gender. It has something to do only and only with religious plurality of the country, accepting the situation prevailing on that day. Now, my lord, further.
Equally entitled to freedom of conscience.
Yes. So, my lord, everything, my lord, man and women, both are equally entitled to all fundamental rights. which is taken care of in 14 and 15. You need not repeat it. And therefore, it is not repetition on gender basis. It is introduced as a religious freedom so that one religion may not take or may not understand it to have been given more rights than another religion.
No religion is superior than the other.
Than the other, no religion is subservient, all are equal. It is, my lord, manifestation of secularism. It has nothing to do with gender. All persons are equally entitled to freedom of conscience and the right freely to profess and practice religion subject to public order, morality or health and to other provisions of this chapter. This also comes for the first time. But propagate word has so far not come. Now see the explanation 2. One is regarding Kirpan. We are not concerned. 2. No person, the right to profess and practice religion shall not include any economic, financial, political or other secular activities that may be associated with religious worship. So worship word continues, my lord. Earlier, my lord, what was used was religion, religious worship, which was objected to by Rajkumari Amrit Kaur and Hansa Mehta, but it continued, which is subsequently changed. I'll come to know.
The word worship is there in the preamble also.
Yes, yes, it is there. It is there, my lord. But in the fundamental rights, the objection was this, that if you say religious worship, some of the reforms which we have made might get nullified, because Constitution was being framed as a stage where there were statutory laws prohibiting sati. Sharda Act was, my lord, against child marriage restraint, etc., my lord. So they would refer to Sharda Act also. Sharda Act is, my lord, the name of the act, my lord, based upon the proponent of that act, my lord. But it was child marriage restraint act. And their concern was genuine, but which is taken care of, my lord, subsequently. My lord, now please see page, my lord, 17, the PDF 20, 10.4.47. Earlier, your lordships have noticed state's power to make a law for social reform was not there. It was only subject to public order, morality and health and other provisions of this part. So it was kind of an unqualified right given. Lord, yes, my lord, 8.4.47. Constitutional advice, my lord, that your lordships can skip 14.4.47. Kindly come to the next date. Aladi Krishna Swami Iyer wrote another letter specifically suggesting a clause empowering the state to enact social welfare legislation as suggested by Rajkumari Amrit Kaur and Mrs. Hansa Mehta. The relevant extract is reproduced here and there. Incidentally, Mrs. Hansa Mehta was the wife of first Chief Minister of independent Gujarat when Gujarat was separated, but she was a leader and an intellectual in her own right. She was there in the Constituent Assembly not because she was wife of Jivraj Mehta. Then, my lord, kindly see the bold part.
She has spoken extensively on
Extensively, yes.
how a governor should perform under the constitution.
Yes, my lord. That is where, my lord, the word constitutional morality came. Constitutional morality is a I'll come to that. It's a separate chapter. It's a political doctrine as to how government, constitutional functionaries, they should behave, function, work. When there is constitutional silence, then there are certain constitutional conventions. And that convention is known as constitutional morality. But subsequently, in the recent years, constitutional morality left that meaning and became a standard of judicial review, which I'll come to that, which was never conceived. Constitutional morality means this. It's how the constitutionally functionaries should function. And there is a material available that this is how they understood. Dr. Ambedkar also understood it in that context only. The famous speech which is being cited for constitutional morality. To meet the point and then the suggestion is this. To meet the point, an explanation or proviso to the following effect may be added. My lord, now the suggestion of the Honorable two ladies, my lord, the right to profess and practice religion shall not preclude the legislature from enacting laws of social betterment and of the people. My lord, the wordings changed, the spirit, my lord, continued thereafter. My lord, now it is something else. That becomes, my lord, Article 25 to 2, B particularly. Then your lordships may come to, my lord, next page, 16,447. Now, I'm skipping everything which is not relevant, my lord, for your lordship's consideration. And therefore, my lord, I'm trying to meet with the report issued with revised clauses on religious freedoms. Clause 16 now guaranteed freedom of conscience, freedom of religious worship, and freedom to profess religion, with a significant narrowing from the earlier practice. Clause 17 to 22 addressed denominational rights, religious taxes, etc., etc., my lord. Now, my lord, it becomes religious worship, my lord. Correct, my lords? I'm not reading it, my lord. It's only a transient provision which ultimately, my lord, went into some changes. Please come to page 19, my lord, PDF page 22. Lord, this is only, my lord, to complete this. Lord, there were discussions that conversion should be permitted as a fundamental right, and therefore the word propagate should be added. This is what, my lord, it says. Subcommittee of minorities was formed with Dr. H.C. Mukherjee as the chairman. Mr. Ruthna Swami pointed out, pointed out that Christianity and Islam are essentially proselytizing religions, and the clauses should permit them to propagate them. Proselytizing means having the idea of converting people. That was one individual view, before the committee. Dr. S.V. Mukherjee noted that the right to build places, we are not concerned, my lord. And then your lordship can, my lord, kindly come to next page, 18,447. Now, my lord, there is a change. The word propagate is introduced in the draft. All persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion subject to public order, morality, or health, and to other provisions of this chapter. And that explanation to the words religious worship, religious practice should be substituted. Then, my lord, rest may not be relevant, my lord. On the bottom is, my lord, recommendation for anti-conversion, etc. My lord, now come to the next page, 21, lord, PDF page 23. The clauses went for discussion and debate before a larger advisory committee to discussion. The discussion accepted the change or to explanation 2 from religious worship to religious practice. Lord, therefore, my lord, the suggestions were again accepted. Chairman Sardar Patel requested Sri Rajgopalachari and Sri S.P. Mukherjee to draft a comprehensive clause allowing the legislature to intervene to reform and regulate secular affairs, only secular affairs. Their proposal was appending a new explanation stating that nothing in this right to practice religion shall debar the state from enabling laws for the purpose of social welfare and reform, and was swiftly approved. That any religion, the state can make a law for the purpose of reform or social welfare. This was approved, my lord. The word propagate was taken up at the instance of Ruthna Swami. Munshi and Iyer noted it was already covered by free speech guarantee, but G.V. Pant intervened and said, at worst, it is redundant and it may not harm anyone to adopt it. The word was thus included. Then clause 17, several members including Sardar Patel, Ambedkar, Munshi and Rajgopalachari debated whether legislature ought to be allowed to prohibit religious bodies from holding property. Rajgopalachari offered a middle path, retaining the clause, but qualifying it with subject to general law. This becomes 26D in a different format, but the same thing, right to own and administer property, but not an unqualified right as per the law. So the state can make the law. The debate of anti-conversion clause 21 and 22 between Sri S.P. Mukherjee, Bakshi Tekchand, Frank Anthony and Ruthna Swami was settled by Sardar Patel's observation that forced and fraudulent conversion was already an offence under existing statutory law and the matter was better left to the legislature. My Lord, then, please see, my Lord, next page, K.M. Munshi. My Lord, the rest may not assist your lordships on these questions. There was discussion on this in minorities committee. Many things may not be exactly worship, but maybe in the sense practice of that religion. You may have to, for instance, the immersion procession of Ganpati. It is not worship, but practice of religion. If you go to the temple, it is worship. Further than that, it will be practice of religion. See Rajgopalachari. The second difference is the right of propagation comes under freedom of expression. There is a sharp difference of opinion on this whether worship alone, whether it may be, should be allowed, or whether practice should be included in our fundamental rights. My Lord, it was with a view to whether to widen it or not to widen it. My Lord, eventually, my Lord, it was widened. My Lord. Kindly, my Lord, turn to the next page 24. Lord, I'm not troubling your lordship. Your lordships having.
Yes.
But did I miss the query, my Lord?
No.
I'm sorry. My Lord, please come to page 24. I'm just, my Lord, shuffling this through, my Lord, because it may not have direct relevance. We'll read 25 textually, and this is how it is interpreted in the judicial pronouncements. Now, my Lord, please come to 27, my Lord, instead of this. My Lord, the rest, my Lord, may not have any. My Lord, this is regarding, of course, conversion. My Lord, the chairman ultimately, my Lord, puts it to vote and ultimately his decision, somewhere in the 10th or 15th line from the bottom, highlighted part, chairman, I consider these are matters to be left to legislation. With the concurrence of the House, clause 21 was deleted, which provided in a fundamental right chapter that conversion should be prohibited. Sardar Patel says this is a matter of legislature. It is already a penal offense. Let us leave it to a legislature. We may take up clause 22. This clause 2 is unnecessary and may be deleted. But please see next page, chairman's final verdict. That was forcible conversion. Forcible conversion is no conversion. We won't recognize it. But ultimately he says that there are laws and there can be a law. There need not be a fundamental right either way. Then kindly come to 29.
There is a difference between propagating religion and forcible conversion.
Converting.
Here, what is protected is propagation of religion.
Yes, not by force or inducement or by coercion, etc. That's exactly, but I didn't read it, but these were the words used by everyone. That if you are converting someone because of force, inducement, threat, coercion, then it's no conversion at all. You can propagate, you can convince someone, you can say this is the better things of my religion, etc. Now, my Lord, some questions, my Lord, your lordships have framed one question. Why was it opened only for Hindus? Article 25 2b says that all Hindu religious places shall be open. All public religious places of Hindu religion shall be open for all sections. Your lordships would get something, my Lord, in this. 1st May 1947. The Constituent Assembly meeting in New Delhi took up Sardar Patel's interim report on fundamental rights. Debate was relatively limited. K.M. Munshi moved to add a specific provision that religious freedom will not prevent laws for throwing open Hindu religious institutions of a public character. I'm reading page 29,
29.
PDF 31, 32.
The top.
I'll read again. The Constituent Assembly meeting in New Delhi took up Sardar Patel's interim report on fundamental rights. Debate was relatively limited. K.M. Munshi moved to add a specific provision that religious freedom will not prevent laws for throwing open Hindu religious institutions of a public character to all classes and sections of Hindus, directly targeting exclusion of Dalits and lower caste from the people. But this was the idea, because we unfortunately were living in a society where one particular part of Hindu was not permitted to be a part of the broader Hindu denomination by denying them right to worship. Again, this had nothing to do with gender. We last decade or so, there is a jurisprudence which is developed where every constitutional provision will have to be seen from the lens of gender. All provisions are not. There is no discrimination. 14, all genders are equal. 15, irrespective of sex, all fundamental rights are equal. This was, my lord, that era-specific provision, that if it is a public temple or public religious institution, it should be open for all. We must do away with this untouchability, etc., section within the section, etc., which was very rightly accepted. I'm highlighting because one judgment has said that this is to ensure that even women can enter. Women were entering all temples. I'll come to that, my lords. Then, my lord, next page, last part. Why section thereof word was used in the, so far your lordships have seen Article 25 did not have the word section thereof. It was only religion. Now it comes because K.M. Munshi, my lord, all were visionaries, my lord. Alladi Krishna Swami Iyer, K.M. Munshi, there were many, my lord. If I name, I would be doing injustice to some other people, my lord. But K.M. Munshi, sir, I move an amendment that in clause 14, the word or a section thereof be added between the word denomination and the word shall. It was felt that the use of the term religious denomination may prevent a section of a denomination from being protected. Lord, no judgment has noticed this part. Sabarimala does not notice even the expression section thereof. It says that Sabarimala or Ayyappa Swami is not a denomination at all. That temple is not a denomination because it is a larger part of Hinduism. So no protection under 25-26. Therefore, I gave an example of Ajmer Dargah, where everyone goes. It's a section thereof. In Shirdi, everyone goes. It's a section thereof. In Tirupati Balaji, all Hindus go. Shaivites, Shaktyites, Vaishnavites, everyone goes. But it is a denomination because it takes care of faith and belief of a section of the Hindus. So denomination and a section thereof, that was suggested. And no judgment takes, Lord, at least Sabarimala does not even notice whilst holding that Sabarimala is not a denomination, because it is a Hindus also go and Muslims also go. And I can give 50 examples of shrines, places, dargah, where all community people go, or places where, for example, Dwarka, Srinathji, it is essentially a Vaishnavite denomination, but Shaivites also go, Shakta Sampradaya also go, every Sampradaya goes. So you cannot say that it is ultimately Vaishnav denomination, and therefore it would not get the protection of 25 and 26. Therefore, the word section thereof. Page 32. Lord, in this court, yes, yes. Exactly. Balaji. Lord, I'm sorry, my lord, if I'm going little. Lord, in case of Dargah committee, Lord, that is Ajmer, the five judges bench of this honorable court did held that it is a denomination and it is rightly held. One of the reasons why it was referred to was this anomaly. That why, how can you, it's a section thereof. Why are you not doing it? Look, the only problem with Dargah committee was, for the first time, it introduces essential religious practice doctrine. And it goes to the extent of saying that not only essential religious practice, your superstition is not protected by 25 and 26. Nobody says superstition should be protected, but who will decide whether it is a religious practice or a superstition? Courts certainly cannot decide. If it is a superstition, I'll give your lordships, I have compiled laws which prohibits superstitious acts under Article 25(2)(b, social reform.